I'm Dr. Daria Shirakova, and I'm the founder of Houston Place of Arbitration. It's a think tank promoting Houston, as well as energy law, energy arbitration, and also I'll share the information and knowledge. And today is our inaugural session of All Roads Lead to Houston series, and our first ever guest, Julien Fouret, who is a partner at H at HFW and also the Secretary General of Paris Arbitration Academy, which a lot of people attended, including myself. So I'm really excited to talk to him. He's also the author of a book on enforcement of investment treaty arbitration awards, which had already 2 publications in 2015, 2021, and is also coming in updated version in May 2026. So you can read this book once it's out. And the topic of our today's webinar is enforcement of intra-EU awards from a European perspective. And I know that some of you know about all the problems with the enforcement of intra-EU awards, but those who don't know, Julien is the best person to talk to. So Julien, but first, the most important question to begin, do you have any links to Houston? Because the topic is all roads lead to Houston. I hope that everybody who we invite has some links to Houston, at least some little links.
No, yes, actually, I've lived a year in Houston when I was in high school. I was an exchange student in Houston in a few decades ago, let's put it that way. So yes, I spent a year of studies in Houston, and I came back a few times by them. So yeah, it's a city close to my heart.
Perfect. So let's go to the topic of our discussion and start with a general question. How do national courts of member states act when they are asked to enforce an ICSID award? Is it different from any other commercial award or non-ICSID award?
Well, yeah, if you take the principle, I mean, in terms of the general principle that should be applicable, yes. The ICSID convention was actually designed as a self-contained system with almost, I would say, automatic enforcement. Unlike, for example, the New York Convention on the Recognition and Enforcement of Arbitral Awards, the ICSID convention sought to limit as much as possible the role and the involvement of national courts. So if you take all the issues that could arise in a post-award contest, where ICSID effectively has its own internal review mechanism to start with. Article 50 allows you to apply for clarification as to the meaning of the scope of the award. 51, so revision of the award if there is any issues that can arise when you read the award. And then 52, which is even more new when it was created in 65, and still something that is almost unique. 52 for the annulment, or what we call setting aside of the award. It's only done by an ad hoc committee selected by ICSID itself. So that's part of the answer. The other part of the answer is relating to the compliance, the recognition, and the enforcement of the award, which was actually your question. And for this, it's 53, 54, and 55 of the ICSID convention. And it's very interesting because 53 addresses each of the host states' obligations to comply with an award, which is a party to the arbitration. 54 obliges all contracting parties, so all contracting states, not only the one that is involved in the arbitration, but also all the other ones, to recognize and to enforce an ICSID award, irrespective of whether that state was a party to the disputes, as a final decision of its own courts. So basically, Article 54 says that an ICSID award should be considered by all the contracting parties as if it was a decision in last instance, so with no recourse anymore, of its own courts. And 55 confirms that this obligation of recognition does not, however, override some local laws on sovereign immunity from execution. So in principle, by showing the original ICSID award, final award, to the enforcement judge in whatever contracting parties you want to enforce it, you would obtain a right to automatic enforcement as if it were a final decision of a court of that jurisdiction, and you could eventually start seizing assets almost automatically. So it's really a unique system in which you can enforce an award automatically on the territory of the 155 contracting state of the ICSID Convention.
So I understand that normally the enforcement of ICSID awards is an international obligation of a state. So what happened? How did it happen that European states stopped enforcing it, or at least there's so many difficulties linked to that now?
Well, because I think the European Union wanted to meddle with investment arbitration and had to find a way, if I want to be a little sarcastic about it. But yeah, everything arose from the ACMEA decision that you probably all of you know, but just for those who might not know, just to
We
go
have
back
some
on that.
people who don't know, yes.
Yeah. So to go back on it, ACMEA is a case originally based on a bilateral investment treaty, so what we call a BIT, between the Netherlands and Slovakia, to which between the Netherlands and Czechoslovakia, to which Slovakia subsequently succeeded. And a Dutch investor obtained an award that was granting it 22 million euros against Slovakia under the 2022 ancestral rules and arbitration based on the BIT. Slovakia tried to get the annulment of the award before the German courts because the seat of the arbitration was in Germany. The Federal Court of Justice in Germany referred a question for what we call the preliminary ruling to the European Court of Justice, which is basically when for those who don't know the complete European system, when local courts in the European Union have questions, they refer some preliminary questions and obtain a preliminary ruling from the European courts to have answers to some of the questions. And this was the case. Grand Chamber of the European Court on 6 March 2018 said that arbitral awards established under the BIT, so this one, but also all the BITs, may be required to interpret or apply EU law when they were deciding on the dispute before them, both as part of the national law that they might be applying, but also as part of international law in general. However, what the court says, the European Court says that such arbitral tribunals are not regarded as court or tribunal of member states. They do not form part of either the Slovak or the Dutch judicial systems for whose jurisdiction they derogate, so they don't have that right for preliminary ruling of the European Court. Consequently, they're not entitled to submit such questions to the courts, and for the national courts of the member state, they may review the compliance with EU law of the arbitral awards only to the extent permitted when it's possible because of the setting aside that might be submitted to them. So ultimately, and in a nutshell, the European Court held that recourse to investment arbitration in the context of an investment dispute between an investor of the European Union and a member state of the European Union, what we call an intra-EU dispute, where such recourse is based on a bilateral investment treaty between two European states, this is incompatible with EU law, and therefore BIT in the European Union should not be existing anymore.
And so what are the consequences for those who want to enforce the awards in Europe of these ACMEA decisions? And also, are there any consequences going beyond Europe in this case?
Yes. Well, yeah, there are many sides of that question. When you look at the decision of ACMEA, it based itself on two articles of the Treaty of the Union. One, which is Article 344, which obliges member states not to submit a dispute concerning the interpretation or application of the treaties to any method of settlement other than those provided for in the treaty. So basically the European courts and the domestic courts. And Article 267, which is on the preliminary questions. So basically not having that available for tribunals should have a consequence. The consequences of ACMEA is that European investors have supposedly lost access to an independent international arbitration tribunal in order to obtain compensation for damages they suffered in an investment that they have made on the territory of another EU member state. And so basically the arbitrator who in principle replace the natural courts and who belong neither to the local legal order or to the investor's home state legal order would disappear entirely. After the decision in 2018, all member states drew the consequences of the ACMEA decision, and on 15 January 2019, they've actually issued a declaration expressing their commitment to terminate all the BITs in force between them, which means that no other bilateral investment treaty should be existing between the states of the European Union. The declaration has established, for example, an obligation for the member states to put in place the necessary remedies to ensure effective judicial protection for investors' rights as enshrined in union law. In particular, in that same declaration, the states have undertook to ensure that their courts, so the domestic courts, would meet the requirement of effective judicial protection that basically was afforded under the BIT. A few months later, following that declaration, in May 2020, 23 of the 27 member states signed an agreement for the termination of all the BITs. So after 29 of August, when that agreement came into force, no more BITs internal to the European Union. So since the ACMEA judgment and pending the establishment of European investment law regime that would probably oversee all those issues, investors are therefore deemed to be compelled to have recourse to the state national courts, to the EU member states. Unfortunately, and frankly, it's unlikely that that solution is sufficient for investors because given the general lack of confidence in some of the national courts and the reasons why actually those BITs were put in place, it puts at difficulty some of those investors, and all, or at least the overwhelming majority of decisions of the courts show that investors continue to rely on arbitral tribunals and attempt to circumvent ACMEA by one way or another, by either seating their arbitration somewhere else than in the European Union and trying to have courts that are not from the EU to decide on some of these issues when they come to the setting aside or the enforcement or at the enforcement phase. Sorry, but it's a real issue because in principles, as we've seen, there is very limited scope of review for the ICSID system when you're before the European courts. But what has happened now is that because of ACMEA, courts are feeling a bit more confident. So when you're in the European Union, they feel more confident and feel like they can have a harder review and basically force the parties just to stop enforcement procedures or actually set aside the words, whereas they shouldn't have in the past.
Julien, you talked about Article 54 of ICSID Convention. So
Yeah.
Now it seems like there's a conflict between this absolute supremacy of EU law, according to the decision of the EU Supreme Court, and now we have this conflict between the ICSID Convention and European law, right? So how are European domestic courts resolving this conflict?
Well,
Do they try to do something?
I think, I mean, if I want to be again a bit sarcastic, I think they try to avoid thinking that there is a conflict, and by saying that because EU law is there and we've been imposed that by ACMEA, it doesn't matter what our other obligations are, and so we don't care about it. I think there is something more that can be done about it, and more, I would say, legally accepted, at least for on an international scale. So as we said, in principle, very limited scope of review for national courts because of Article 54 that says it contains no express grounds on which the parties can resist enforcement. And that's why it has led to say that it was automatic. While it is more insulated than in the New York Convention, one potential qualification to the automatic nature of Article 54 can be of use if courts want to try to actually accept what international law should be in terms of the hierarchy of norms. Article 54 refers to recognition and enforcement of an ICSID award, and I quote, as if it were a final judgment of a court in that state. Mm-hmm. This could suggest or tend to suggest that if there were grounds to refuse enforcement of a domestic judgment for whatever reasons, those grounds would also govern eventually the enforcement of ICSID awards. So this is therefore one potential basis of the refusal to enforce while trying, I would say, to preserve and safeguard the ICSID system, which is absolute primacy of EU law over the ICSID Convention, if you look at what the decisions of the EU courts are, and have here a valid ground to, according to this domestic jurisdiction, refuse enforcement. But this is, I believe, in terms of international law, is probably incorrect, but that's the only way that they can do it, to try to respect the hierarchy of norms of international law. And there are actually avenues under the ICSID Convention if states actually wanted to confront some of the EU states to these problems to have a decision on these points. Because if you go back to the Article 64 of the ICSID Convention, there can be dispute between states contracting party to the ICSID that could be referred to the ICJ, so it's a long shot, to have an interpretation of the ICSID Convention to say what it means and who is superior to what. It's unlikely that states will go that route, but nonetheless, it still exists. So if there is a state that is really unhappy about it, it can try to do it. When you look at some other jurisdictions, for example, and we will probably go back to that, for example, in Switzerland, Switzerland has basically, I would say, if I put it in layman terms, has schooled the EU domestic courts in terms of international law. But so far, local courts, so domestic courts, have refused to get into any discussion and have blindly applied the ACMEA decision, unfortunately.
Thank you, Julien. That's very, very interesting approach. And it's true that here in the US, people don't really speak about it. And before I'll ask you more questions that we prepared, as a French lawyer to French lawyer, I really need to ask that. I know that we didn't discuss it before. So what do you think in the terms of legal orders? Do you think that the European Union is trying to replace the international legal order by so-called European legal order, or at least kind of create the third legal order as compared to this dichotomy we always had, international legal order versus national legal orders?
Yeah, I think it's about that. I don't know if they're trying to replace or, as you said, to create a third one, but I certainly think that the European Union is trying to gain more legal grounds, or at least grounds on having a say on more legal issues in the domestic legal orders of the members of the European Union in the 27 member states. And by doing that, and ACMEA is the first step, and then we might go to speak about Comstroil, which has other impacts. But with ACMEA, it's trying to impose the fact that the European legal order is above the international obligations of the states that they have contracted individually, because ICSID is individual states that have been contracting parties, and putting above that whatever the European Union is doing in terms of international obligations, and basically putting above all the international obligations, if there is anything in the European law that comes above that, or that is not actually exactly what the international obligation is, then the European law will prevail, whatever the reasons. And ACMEA, unfortunately, is the first step. I'm not sure it's going to be the last one. And the reason being that I think the European Union want to have more say on investment, which is it's a shared responsibility between the states and the European Union. For intra-EU, it's now accepted because of ACMEA that it's pure European Union led. For outside, that remains to be seen. Outside the European Union, European states still have their say in terms of the BIT that they conclude and in terms of the obligations arising from them, as long as it does not impair on the European law obligations. So European Union has tried to create a third legal system that is, or that at least actually that poses to be above the two other ones that used to be the ones that are in the domestic and international legal system.
Thank you. You just mentioned the Comstroil decision, and it's true that whoever speaks about ACMEA now they speak about Comstroil as well. Can you explain us what is this decision, what happened, and what's it's important for the whole ISDS mechanism in Europe?
Of course. So ACMEA was based on a bilateral investment treaty between the Netherlands and Czechoslovakia. But that judgment does not mention a multilateral investment treaty, which is the Energy Charter Treaty, the ECT. It's a mixed agreement, that treaty, and that's why it's also interesting, because it's concluded by EU member states, by what was the European Community, so the EU now, and by states that are outside of the EU. So it's a mixed system in a sense that it's not only intra-EU and it's not only states, because you also have the EU that is part of it. Negotiations were underway to try to modernize that agreement because EU states were not happy about it. Member states were divided whether to stay into it, to get out of it, but ACMEA didn't address it, so states were wondering whether or not ACMEA had a bearing because it had this clause, which is Article 26, which is exactly the one as in BIT in terms of access to international arbitration for investors against the host state of its investment. Before the European courts clarified the matter, a few courts, notably in Sweden, in the Novenergia and the Green Tech cases, had decided to halt their decision as to whether ACMEA was applicable to the ECT dispute system or not. The ECJ clarified in 2021 in a case between Moldova and Comstroil, so that's why we call it the Comstroil case. By way of background, it was an issue of a contract of purchase of electricity for which Moldova was basically held liable to pay 33 million to Comstroil for violation of the ECT. So Moldova tried to set aside the award before the French courts because the seat of the arbitration was the French courts, and the French courts, Moldova tried to say that the dispute did not involve an investment within the meaning of the ECT. As a result, French court referred the question to the European court, saying it's an issue of investment. It's more precautious if we send it a preliminary ruling. And what's interesting is that it was not part of the submission before the European courts whether or not the ECT was under the issues raised by ACMEA, whether or not the applicability of the ECT for intra-EU disputes was an issue. It was not raised in the preliminary questions, but it was actually decided in the preliminary rulings, I would say ex officio by the European Court. The court reiterated that the autonomy of EU law requires specific protection by means of the European Court having exclusive jurisdictions regarding issues of EU law, and it was impossible for a tribunal to issue an award that would ensure full compliance with EU law and guarantee that the relevant questions of EU law are properly addressed. This also dictated by the final and definitive nature of the ECT award under Article 26(8) of the ECT, which in principle makes it impossible for the European Court to provide an active and meaningful interpretation of EU law if there was any. So according to the court, the ECT may validly provide investment arbitration in relation to member states and investors of third states, but within the Union, this is contrary to the autonomic and specific nature of EU law, and therefore the multilateral character of the ECT is irrelevant in that respect, and basically same result as for ACMEA. European investors cannot rely on the ECT provision regarding arbitration against another EU member states. Same difficulties, same difficulties as for ACMEA.
Thank you so much, Julien. And as you know, in Houston here, we have so many energy companies and a lot of lawyers who are interested in ECT and its application for European companies and states. What do you think will be the consequences of that for the energy companies domiciled in the US versus energy companies domiciled in Europe?
Well, there are two issues. The first one is if they're basing themselves on a for example on a investment instrument that is, or investment company that is based in the EU against the EU member state, it's a losing case, or at least it's a losing case when you get into the jurisdiction into the enforcement stage. But the problem, which is a bit wider than that, is that it's becoming less and less relevant internally in the EU because many states have now denounced the ECT. Ireland being the last one on the 14th of April, allegedly over concerns about the incompatibility with climate change goals, which is something that we can all debate about. The only good thing that you to remember is that whenever a state denounced it, that takes effect a year after that, but there is also a 20-year sunset clause. That means that if you have done an investment and if you have issues arising within that 20 years gap, in principle, you could still use it. But Ireland has denounced it, Lithuania has denounced it, France has denounced it, Germany, Poland, Luxembourg, Slovenia, Portugal, Netherlands, Denmark, etc., etc. So a lot of states. Italy was the first one in 2016. They've denounced it those past few years, which means that it's still valid, let's say, for the next 18 or between 15 to 20 years. But nonetheless, that's a real issue because that means that this instrument will not be available for foreign investors that are based in outside the EU against those EU member states because they've denounced it in general. But what's even more troubling is that the states that remained into the ECTs have made amendments to the treaty in late 2024, which includes provisions to exclude intra-EU application of the ECT now, with having a lot less of the European states members of the ECT. But nonetheless, that might mean, if we want to project it a little bit, that hopefully some states will come back to the ECT because there is not that fear anymore that you will have some intra-EU BIT because of the new drafting of the ECT. Slovakia is still in there and is the first state that of the EU that has ratified the amendments actually last month. So it might grow back because of that new amendments, but for now, where you have to rely on the sunset clause to have it applicable because most of the European major states have denounced it.
Thank you, Julien. Do you think that Comstroil now has constructed this weird bifurcated legal regime for EU versus non-EU investors while they are actually relying on the same treaty?
Yeah, I think the issue becomes that there is not the same protection if you're an EU investor in the EU or if you're an EU investor outside the EU. And you can see a tendency with some of the clients you might have in the energy sector, notably in the biggest European countries, that now structure the investment to have the signatory of some contracts or of some projects to be outside of the EU to ensure that there is no potential effect on those problematics and to see them in some safe, which is French to say when you're in a French environment where you think that arbitration is safe here, but I would say in a safe arbitration friendly outside of the EU to ensure that you would have access. So yes, in effect, there is a two-side road when you're at the ECT, depending if you're into an intra-EU issue or outside that. And it could be problematic for some investors that might have to reorganize most of their investments to ensure that they still benefit from the protection of the ECT.
That's very interesting, Julien, because I have recently thought about it. We had discussions on Houston as seat of arbitration for the Mexican cases. And I know that there were later the same discussions about Madrid as seat of arbitration for Mexican cases and investors. And interesting enough, I was quite skeptical about Madrid, especially and specifically for the reasons you've just told us. And actually, I'm very happy that I'm not the only one who thinks this way. And it's not like I'm completely biased and promoting Houston here.
No, I agree with you. I think it would not be a good advice to give some clients right now if they're based in the EU to sit any of their arbitration in the EU because it will most definitely become problematic at the enforcement or setting aside stage, for sure.
And before we go to the domestic enforcement strategies for the exit cases, I have one last question on this intersection of public international law and the EU law. So, how do you think the European Court of Justice judicial position may be reconciled with the rules of treaty interpretation of Vienna Convention on the law of treaties?
I think if I want to be blunt, I think the European Court doesn't care about the Vienna Convention, which is a real issue, because the way that they've treated the way actually the European Court treats European law is as if it's a legal norm, as we would see in a domestic legal system, like a law or administrative regulation, and doesn't treat it as a treaty, but treat it as what's applicable above any other legal regime in the European Union, and particularly for the European individuals or investors in the European Union. So basically, the European Court does not even consider the questions under international law, but looks at a more domestic way of looking at it, like the norms applicable in the EU between EU member states and EU citizens are what the EU says. Whatever can go against it will not be looked at. If it supplements it and if it doesn't go against the EU, fine. If it goes against it, then we won't consider it. So actually, the European Court does not look at it as we would do, or as we should do as international lawyers, as where you have two different norms, which one prevails over the other because of the international legal system or the European legal systems. But here, it just totally avoids getting into that discussion by saying, if the EU law regulates on this issue, then that's what should be applicable, and and in the international spheres, it's completely different.
Thank you, Julien. I see that we have a question. So it relates to what we have just discussed. So I will ask this question and then we can go further to the discussion of the domestic court's decisions. So it's from Alberto Fortun. Sorry if I mispronounced your name. Can pronounce it in French as well. And the question is, so there, question number one, we should not forget that the whole reasoning only applies if EU law is applicable to resolve the dispute under the ECT. Most tribunals said that EU law was not applicable and that Article 10 of ECT was the sole provision applied. What is your view? Disclosure. I have been acting on behalf of investors against Spain.
Yes and no. I mean, yes, in principle, when you look at ACMEA and Comstroil, it should only be applicable if EU law is applicable to resolve the disputes, and under the ECT notably. And I agree that in most of those cases, EU law was not an issue. It was not raised before the tribunal. It was not a real issue in terms of the substance and in terms of the merits. But the problem of the ACMEA and the Comstroil is that it doesn't seem that it matters as long as it's between a European investor and an EU member states, because the fact that there might be an issue of EU law at the enforcement stage, for example, state aid as it's been qualified, so that means that it's not in the arbitration. So the arbitration will be decided without having recourse to EU law. But when you try to enforce it, then according to the European Court, it might go against some EU rules, then that's enough. So the risk is basically enough, even though I agree that there is no application of EU law within the actual arbitration. But the consequences actually for the European Court is not different. It's exactly the same, because it doesn't make such a fine difference that that Alberto, you've been making here. It just makes a decision saying whenever it's EU investors, EU states, no arbitration, and period, whatever the decision and whatever the merits of the case.
Thank you, Julien. And Alberto has second question. So second question is, in your view, based on Article 64 Exit Convention, maybe that's 54. Let's do, yeah, 64 Exit
64,
Convention.
yeah.
Could a
Yeah,
non-
I think it's the question I've raised before. It's probably the action of states against states.
Let's see. Yes.
Yeah.
Could a non-EU state party to the Exit Convention bring an action against Spain? Yes, that confirms what you just said. Against Spain, Sweden, and other member states that are not compliant with their obligations under Article 64 Exit.
Yeah.
Example, UK, Australia, or US.
Yeah, I think it's what I mentioned, is that it's the only way I can see any potential actions at the international level. I mean, Article 64 has never been actioned. So it's always a bit complicated to talk about it. But yes, as a matter of principle, in theory, a state that doesn't like the way that one of the other contracting states applies the ICSID convention, or feels that one state basically acts in contravention of its obligation under the ICSID convention, it could ask the ICJ to solve a dispute in terms of interpretation and application of the ICSID convention through Article 64. The only issue here that I see, I mean, the potential is actually there, is trying to ask them why don't they respect the ICSID convention, and they prefer to respect the EU law above the obligation that they have under the ICSID convention. The only thing is, and if I want to be a little bit, again, sarcastic, is I think some of those states benefit from that situation, in a sense that it was mentioned the UK, for example. We know that the UK is benefiting from not being in the EU. That's one of the rare benefits that they have right now, of not being in the EU anymore, and can be the seat of arbitration and be able to sometimes actually enforce awards that might not be the case in other situations, particularly if they were in the EU, and accept the enforcement of EU awards because of the fact that they're not in the EU and not bound by EU law anymore. And that's interesting, because that's why I think the states that could actually make an Article 64 plea before the ACJ actually benefit from that situation, that them, unless they want to do it for the beauty of the law, which I doubt, I think they will never activate it. But that's the only way to actually put an end, or at least at the international level, to try to put an end to what the EU is doing, and some of the states like Spain, Sweden, or Italy.
It seems like, thank you so much, Julien. It seems like now the situation created a healthy competition for seats of arbitration outside of the EU, and also for the enforcement lawyers outside of the EU. And I know that you wanted to discuss not only well-known decisions of UK, Australian, and US courts, which put forward the supremacy of international law, but also not very well-known Swiss decisions. So can you tell us more about this Swiss procedures?
Yes. Yeah, because I mean, as most of you know, I mean, Switzerland is the country that has the most seated arbitration in the world. When you know all the analysis that has been done in commercial arbitration and now starting investment arbitration, a lot of the arbitration are now seated in Switzerland. And yes, there was an extremely interesting decision in 2024 in April 3rd. So the Swiss Supreme Court dismissed a challenge made by Spain to an arbitral award under the Energy Charter Treaty in favor of EDF Énergie Nouvelle, so EDF, so the French electricity provider. And this pivotal decision notably disregards totally the Court of Justice of the European Union judgments in ACMEA and in Comstroil, and reinforced the validity of intra-EU arbitration under the ECT in Swiss jurisdiction. And that's very interesting. Just to give you a bit of background, basically it's the classical arbitration of the 2008, 2008 Spain measures introduced regarding investment in renewals. EDF started an arbitration. The Geneva City Arbitral Tribunal, based on the ECT, awarded more than 29 million euros to EDF for breaching the fair and equitable treatment standard. Spain challenged the tribunal's jurisdiction and contested it, arguing that its consent to arbitration under the ECT did not cover intra-EU disputes, and that Article 26 of the ECT was incompatible with EU law, which should prevail. So basically, Comstroil. They pleaded Comstroil before and ACMEA a little bit, before the Swiss Federal Tribunal. The Swiss Tribunal highlighted that the European Union rulings are binding only on EU member states and not on Switzerland. So that's the first point. It says that this issue is an EU issue. It's not binding on outside of the EU. Despite usually considering foreign case law as relevant, here the Swiss Federal Tribunal criticized the European Union approach in ACMEA and in Comstroil as driven by the autonomy of the EU law rather than international law principle, in very harsh words. And it even said it viewed the European Court's stance as part of an EU, and I cite as an EU crusade against intra-EU investment arbitration, thus deciding not to accord any weight to ACMEA or Comstroil judgments. So the Swiss Supreme Court, which is generally very deferent to foreign judgments, here just said, I don't care about it, basically. And so the SEC examined Article 26 of the ECT, which is the arbitration clause article, using, contrary to the European Court, the Vienna Convention on the Law of Treaty, and notably Article 31, interpreting it in good faith according to the ordinary meaning and to what its term actually says. And the court found that the ECT language provided for unconditional consent to arbitration with no carve-out for intra-EU disputes. And the SEC further dismissed all the arguments based on other ECT provision, noting that no other provision did support the exclusion of intra-EU disputes. And the court asserted that the ECT aimed to promote international cooperation and energy investments would be completely undermined by excluding intra-EU arbitration when 3/4 of the actual members of the ECT were EU members. And it rejected all the reliance of Spain on the declaration of the ministries, of the statement of the European communities, etc., etc. The court also referenced to the absence of any disconnection between ECT final text and whatever the parties are trying to accept. And finally, it dismissed also Spain's argument that EU law, post-Treaty of Lisbon, rendered the EC incompatible. And it cited cases like Vattenfall versus Germany, where the court maintained that EU law did not invalidate pre-existing treaties like the ECT, saying that the ECT still existed. And so for the Swiss Supreme Court, Article 26 is still applicable, and Article 16 of the ECT, and it's even more interesting because that's a real analysis under public international law. It says that Article 16 of the ECT ensures that its provision took precedence over conflicting treaties, including EU law, something that the Comstroil does not talk about at all. What's interesting is that following that ruling, Spain actually confirmed its withdrawal from the ECT, and despite this, the ECT sunset clause will still apply. But nonetheless, that has been reaffirming the validity of intra-EU arbitration under the ECT when it's not seated in Europe. That's very interesting, despite the actual decision that you have in intra-EU, which is actually saying exactly the same. So if an investor seeks an enforcement or actually have a seat anywhere but in Europe, but not in the European Union, Switzerland might be the place to go, which is a hard thing to say for a French person, but nonetheless, I think it's right now it's a safe space for that, because actually the tribunal, le Tribunal Fédéral is doing like a proper international law analysis, which is very good.
If you had to choose between Switzerland and UK, well, thinking about the proximity, what would you choose?
Switzerland. Not because it's a civil law country. That's not the reason. The main reason being that the Swiss Federal Tribunal has a very constant and stable case law that is easily understandable and easily and is very stable. Is that there is no analysis that goes beyond what is necessary. And you have the federal judges that they don't have, like in France, they have a special part of the court that does only arbitration, but they have very strong knowledge of international law, of international arbitration, and it's very stable and it's very understanding of the interest of the parties. And they have the lowest rates ever of setting aside of awards. So they set aside awards where it's really, really egregious, when there is really issues that you can't accept to enforce an award that has suffered breaches of whatever principle you want. But otherwise, it really protects the investment arbitration and the commercial arbitration award. And I think for me, it's probably one of the safest seats that we have around the globe these days.
And what do you think about the US approach to the same issues?
It's interesting because when I went back to that, there has been in 2023 two conflicting decisions by the same district court in the US, which is something very, very odd to say for a foreigner, because the fight has been between two judges of the US District Court of DC in 2023, which issued conflicting decisions under the Foreign Sovereign Immunity Act. One judge found that it had no jurisdiction to enforce intra-EU awards under the FSIA. It was in 29th of March 2023, in Blasket Renewals, Judge Leon dismissed an action to enforce an intra-EU arbitral award against Spain for lack of jurisdiction under the FSIA. And it's interesting because the judge agreed with Spain that EU law, which derives from treaties between the EU member states, form part of the rules of international law that apply to EU parties under the ECT. And for Judge Leon, it accepted the arguments that two recent decisions, namely ACMEA and Comstroil, established that EU member states are legally incapable of agreeing to arbitrate with other EU parties under investment treaties, such as the ECT, as a matter of EU law. So basically, incapable of having to accept arbitration because it's intra-EU. Judge Leon found it did not have jurisdiction to enforce this award, as it was established that EU member states are legally incapable, again, of agreeing to arbitrate disputes between EU states and EU investors. What is funny enough is that 1 month before that, another judge found the completely opposite, found that jurisdiction to enforce intra-EU awards. And it was Judge Shutkan, also of the DC Supreme District Court, issued two decisions upholding jurisdiction over actions to enforce intra-EU awards against Spain in the 9-REN and in the Nextra versus Kingdom of Spain. Unlike Judge Leon, Judge Shutkan rejected the view that the court had to decide the question of the existence of a valid arbitration agreement at the jurisdictional stage. The judge, she refused to rule on its validity, stating that it was irrelevant for her own analysis. One of the key reasons, and I think that's very interesting, for this judgment was the protection of the US public policy interest, that is, the protection of the lawfulness of this jurisdiction and encouragement of international arbitration award enforcement. Spain tried to dismiss enforcement of the ICSID award, again, on the ground that the ECT arbitration clause was incompatible with EU law when it used it in its intra-EU investment arbitration proceedings. The court heard the intra-EU objections. However, it stated that it did not affect its own jurisdiction. Hence, there was no need to analyze its merits. It's interesting because that means that for that judge, you could go in front of it and try to enforce an arbitral award. What's more interesting is that in August 2024, so a year and months later, the US Court of Appeal for that Supreme Court sided with Judge Chutkan, further paving the way for actually Prospect to enforce intra-EU awards in the United States by ruling in favor of Nextera and 9-REN on appeal filed by Spain following the Judge Chutkan first instance judgment. It refused Spain's petitions for lack of jurisdiction due to sovereign immunity, opining that the US Foreign Sovereign Immunities Act contained a carve-out for the enforcement of foreign arbitration awards. So enforcement prospects, if I must say, are thus looking better in the US so far than if we were to stop only at the Judge Leon decision. So it's interesting. So we'll see what happens, but it seems a bit better than it would have been a few years back.
Thank you, Julien. And it seems like the US courts, they do consider that the international law is still superior to the EU law, right? Whether you take it as a separate legal order or whether you take it as just one part of the national legal orders. Thank you so much.
It doesn't feel bound by the EU law, which is important.
That's very important. Seems like that may be a solution for the investors, at least some of them. Thank you so much, Julien. I'm so happy you accepted our invitation, and it's rare to have people who really are passionate about what they're doing and they come and share their thoughts. Don't forget that Julien's third edition of the book on enforcement of awards will be out in May 2026. So if you're interested, I recommend to read it. And also, if you liked this webinar and you want to share it with your colleagues or friends, it will be on the Houston Place of Arbitration YouTube channel, and also as a podcast, which is very practical because you can just learn while driving or walking or doing anything you want. Thank you so much.
Thank you. Bye bye.
Bye.